Hello, my name is Kevin Snyder of Snyder Law, and I help families protect what matters most to them, their loved ones, their dignity, and their legacy. And today we're going to be chatting briefly about the problems of the new Secure Act that went into effect January 1st this year, 2020. And we've talked previously about why this new law is a benefit to individual retirement account holders, but today we're going to be focused on what the problem can be. And the big problem is the new 10-year rule. What is the new 10-year rule? The new 10-year rule under the Secure Act states that non-spousal beneficiaries of qualified retirement accounts will have to withdraw the entire principal of that account within 10 years of the individual account holder's death. What that means is any beneficiaries that are not current spouses at the time that the actual retirement account holder dies is going to have to remove all of the money in the retirement account within 10 years. They will no longer be able to keep it in an inherited retirement account for longer than a period of 10 years. Why is that a problem? Well, the rule before was that a beneficiary that was a non-spousal beneficiary, somebody that wasn't a spouse, could keep that money in a retirement account for longer than 10 years. If this was set up in a good way, then that person can keep that retirement account for their entire lives. So you can have a person with an individual retirement account, an IRA or a 401k, die and leave a beneficiary, such as an adult child or grandchild, for example, and that child or grandchild would have been able to inherit that account and keep the money in that account for their entire lifetime. Of course, they would have to make certain minimum distributions every year, but the principal would be able to grow tax deferred over a longer stretch of time. Life expectancy of the beneficiary, so their lifetime. Now, the new law says, nope, we're going to cap that at 10 years. The longest amount of time that a beneficiary who's not a spouse can keep that money growing tax deferred is going to be 10 years. So the 10-year mark, that account has to be completely drained, otherwise there are going to be major penalties. So this is a major shift. And the reason why this is a problem is, number one, there's going to be accelerated taxes for your beneficiaries. They are going to not receive as much value of what's in the retirement account because they're not going to achieve the tax-deferred growth. So the ability for principal in a retirement account to grow tax-deferred is certainly something of benefit. And the ability to pass on that principal in the retirement account to beneficiaries and allow them to continue that tax-deferred growth was known as stretch out. It was stretching out the length of the life of the retirement account, because your retirement account is based on your life expectancy. That's why when you now turn 72, you're going to be required to take out minimum distributions that are going to be calculated based on your life expectancy at that time. And of course, if you outlive your retirement account, then your account's going to close because you have had to withdraw so much and you've lived so long. But you have an ability to extend the life of that retirement account beyond you by leaving beneficiaries. And those beneficiaries were able to inherit those accounts and then allow the principal to grow tax-free on a new life expectancy. Not yours anymore, but theirs. So that meant that the life of the account could extend beyond your life expectancy for a longer period of time. So that account was being stretched out, hence the name stretch out. And that is what the new 10-year rule destroys completely. There's not going to be a stretch out for most. We'll talk about exceptions, as I mentioned at the end of the video, in our next video, but for majority beneficiaries, there's not going to be any stretch out anymore of these assets, at least not beyond 10 years. That's going to be the limit of a majority of retirement accounts that are going to be inherited by our beneficiaries, 10 years. There, of course, could be in some situations that we're trying to avoid an even worse 5-year rule. We'll talk about that in another video. But for right now, I want you to grasp the concept that 10 years these accounts stop, and that is now going to be the new lifespan of the inherited retirement account, 10 years. No more stretch out for a majority of our beneficiaries. To their liabilities. And so there is going to be reduced liability protection. Formerly, retirement accounts were safe havens and for beneficiaries. We knew that we can leave larger retirement accounts to beneficiaries, knowing that the principal was going to be protected from the other drivers on the road, the creditors and predators, because only smaller amounts of minimum distributions were going to be required to be taken out. The larger principal in the retirement account was going to stay there, grow tax deferred, and also be protected against lawsuits, divorce, bankruptcy, and that's no longer. So take a look at an example. I said we come back to it. I used to be able to tell clients and explain to them, look, we can take your retirement account, even a $300,000 retirement account, and depending on what beneficiary we want to leave it to, based on their life expectancy, we could potentially turn that $300,000 into $2 million worth of value for that beneficiary over their lifetime. So again, $300,000 when you pass away, leaving to a younger beneficiary could turn into $2 million over life expectancy, assuming that that money is only was withdrawn at minimum distributions over their lifetime. That's a lot of value that could have benefited that child or grandchild over their lifetime and would have been protected from any creditors and predators over that time span. However, that's not the case anymore. You're not going to be able to turn $300,000 into $2 million. Why? Because that money is going to have to come out of the retirement account within 10 years. It's not going to be able to experience that tax-deferred growth. And once it comes out, it's going to be subjected to your creditors or predators. So if you're sued, any money that comes out and sitting in your beneficiary's bank accounts could be taken in a lawsuit, could be divided up in a divorce, and certainly is not free from any bankruptcy or debt creditors. And lastly, of course, if the issue is the beneficiary themselves, and that they have spendthrift habits or they have a questionable lifestyle and they're not good money managers, then of course you're moving and shifting larger amounts of value for their benefit into their hands that is not going to last very long. So that's a big problem that the 10-year rule is going to present. We're going to be talking more about other exceptions to these rules, because with every rule there's an exception. Not all beneficiaries are created equally, and so not all beneficiaries are going to be subjected to this 10-year rule, and we'll talk about that more in the next video. So again, my name is Kevin Snyder of Snyder Law. I'm an estate planning and elder law planning attorney, and I help families maneuver through new law changes like the Secure Act and help them protect their loved ones, their dignity, and their legacy. Hopefully this was of value to you. Please check out our other videos on a variety of different estate planning topics, and certainly the other videos we have on the Secure Act. And again, hopefully this was valuable to you, and hope you learned something. And we'll be talking soon. Take care.